Your landlord just installed a smart lock on your front door. Says it's for security, says it's more convenient. What they're not telling you is that they now have a digital record of every single time you enter and leave your home. And in 18 states, that's now illegal. Before we dive in, do me one favor, hit that subscribe button right now. Why? Because 90% of renters have no idea their rights just changed. And I don't want you to be one of them. The information I'm sharing today could save you from an illegal eviction and protect your privacy in ways you never thought possible. So click that button and let's get into it. Here's what just happened. As we entered 2026, a wave of tenant protection laws swept across the country, and buried in these laws is something most landlords hoped you'd never find out about. It's called the Smart Home Technology Disclosure and Consent Act, and it fundamentally changes what your landlord can and cannot do with technology in your rental unit. Let me be crystal clear about this. If your landlord installed a smart lock, a Wi-Fi enabled thermostat, or any internet connected device in your unit without your explicit written consent, they're breaking the law, not bending it, breaking it, and the penalties are steep. We're talking fines up to $5,000 per violation, mandatory removal of the devices, and in some cases, you can sue for invasion of privacy. Now, I know what you're thinking. My landlord said it was in my lease. I signed something. Here's the thing. Even if you signed a lease that mentioned smart home devices, if that lease was signed before January 2026, those clauses are now legally void in participating states. The law specifically states that any prior agreement allowing landlord-controlled smart technology must be renegotiated under the new terms. You have the power to say no, and your landlord cannot retaliate. Let me tell you why this law exists in the first place. Over the past 5 years, there's been an explosion of landlords using smart home technology to monitor tenants. And I'm not talking about reasonable security measures. I'm talking about tracking when you come and go, monitoring your utility usage to the minute, using smart speakers to record conversations, and even adjusting thermostats remotely to force tenants out. Sounds dystopian, right? It was happening. In 2024 alone, there were over 3,000 documented cases of landlords using smart technology for harassment or illegal eviction attempts. One case in Portland made national news. A landlord installed smart locks that would automatically change the access code if rent was even 1 day late. Tenants would come home from work and couldn't get into their own apartments. Another case in Austin involved a landlord who used smart thermostats to make units unbearably hot in summer, trying to force tenants to break their lease. These aren't isolated incidents. They were becoming common enough that tenant advocacy groups pushed for legislation, and in 2026 they won. So let's break down exactly what this new law does and what it means for you. First, the law requires explicit written consent for any smart device that collects data about tenant behavior or can be remotely controlled by the landlord. This includes smart locks, video doorbells, smart thermostats, smart meters, Wi-Fi routers provided by the landlord, smart smoke detectors that report to the landlord, and even smart appliances that send usage data. Notice I said explicit written consent. That means a general clause in your lease that says landlord may install security features doesn't cut it anymore. The law requires a separate document that specifically lists each device, explains what data it collects, states who has access to that data, and details how long the data is retained. Quick question before we continue. Are you subscribed yet? No? Then you're missing out on updates that could protect you from landlord overreach. Hit that button now because what I'm about to reveal next is the part that even tenant lawyers are just starting to understand. Here's where it gets really interesting. The law doesn't just apply to new installations. If your landlord already has smart devices in your unit, they have 90 days from January 2026 to either get your consent under the new rules or remove the devices. That 90-day deadline is coming up fast for many landlords, and most of them haven't done anything yet. They're either hoping you won't notice or they're betting you won't enforce your rights. Don't let them win that bet. If you're living in one of these 18 states, and I'll tell you which ones in a moment, you have the right to demand a full inventory of every smart device in your unit. Your landlord must provide this in writing within 15 days of your request. And if they don't, you can file a complaint with your state's housing authority. The 18 states where this law is now in effect are California, New York, Washington, Oregon, Colorado, Illinois, Massachusetts, Maryland, New Jersey, Connecticut, Rhode Island, Vermont, Minnesota, New Mexico, Nevada, Hawaii, Delaware, and Maine. If you live in any of these states, you're protected. If you don't, pay attention because similar laws are being debated in 12 more states right now. Now let's talk about what you can actually do with this information. If you discover your landlord has been using smart technology without proper consent, you have several options. Option 1, you can demand immediate removal of the devices. Your landlord must comply within 30 days or face penalties. Option 2, you can consent to the devices but negotiate terms. Maybe you're okay with a smart lock as long as the landlord doesn't have access to entry logs. You can specify that in your consent agreement. Option 3, you can file a complaint with your state housing authority and potentially sue for damages if you can prove the technology was used to harass or discriminate against you. Here's a real example of how this played out. A tenant in Seattle discovered her landlord had installed a Wi-Fi router in her unit that was logging every device that connected to it. Not just when devices connected, but detailed usage patterns. The landlord claimed it was for network optimization. Under the new law, the tenant demanded the data logs. Turns out the landlord was using the information to track when she was home, when she had guests, and was building a case to claim she was violating the lease's guest policy. The tenant sued. She won a settlement of $15,000 plus all legal fees, and the landlord was fined an additional $25,000 by the state. This isn't theoretical. It's happening right now. Let me give you another scenario that's catching a lot of renters off guard. Smart thermostats. Sounds innocent enough, right? Your landlord installs a Nest or an Ecobee, tells you it'll save money on utilities, everyone wins. Except here's what they're not telling you. These thermostats collect detailed data about when you're home, what temperature you prefer, and your daily routines. That data can be subpoenaed in eviction proceedings to prove or disprove various claims. Even worse, many landlords retain remote access to these thermostats. Under the new law, if your landlord wants to keep a smart thermostat in your unit, they must give you exclusive control. They can't have a master override, they can't adjust it remotely, and they definitely can't use it to collect data on your occupancy patterns without your consent. If you're finding this helpful, imagine what you'll learn in my next video about the 5 landlord tactics that became illegal in 2026, things that landlords have been doing for years that are now prosecutable offenses. Hit subscribe right now so you don't miss it, because this is just the tip of the iceberg. Now here's the part that really shocked me when I first researched this law. The penalties for landlords who violate it are designed to be severe enough to change behavior. We're not talking about a slap on the wrist. If a landlord knowingly collects data from smart devices without proper consent, that's a minimum $5,000 fine per device. But it gets better. If they use that data to harass, discriminate, or attempt to illegally evict a tenant, the fines can reach $50,000 and they can face criminal charges for invasion of privacy. In some states, tenants can also sue for actual damages, which means if you can prove financial harm from the landlord's actions, you can recover those costs plus attorney fees. Let me tell you about another case that illustrates why this matters. A landlord in Brooklyn installed smart locks on an entire apartment building, told everyone it was for package delivery and building security. What he didn't disclose was that he was tracking which tenants were coming home late at night, which ones had frequent visitors, and which ones left for extended periods. He then used this data to selectively target tenants for lease violations. One tenant, a nurse who worked night shifts, was accused of not using the unit as her primary residence because she was often gone overnight. The landlord started eviction proceedings. Under the new law, the tenant was able to subpoena the smart lock data and prove the landlord had been collecting it illegally. Not only did the eviction get thrown out, but the landlord ended up paying $40,000 in damages and had to remove all smart locks from the building. The judge in that case made it very clear. Landlords do not have unlimited surveillance rights over their tenants, and technology doesn't change that fundamental principle. Here's what most people get wrong about this law. They think it's anti-technology. It's not. You can still have smart devices in your rental. You can install your own smart lock if your lease allows it. You can set up your own security cameras inside your unit. What the law does is prevent landlords from using technology as a tool of control or surveillance without your knowledge and consent. The key word is consent. Informed, voluntary, specific consent. Not buried in page 37 of your lease, not implied by your signature on a move-in checklist. Explicit, documented, informed consent. And here's the beautiful part. You can revoke that consent at any time with 30 days written notice. So even if you initially agreed to smart devices, if you change your mind, the landlord has to remove them or give you exclusive control. Now, let me address the landlords who might be watching this. I know some of you are thinking, this is my property. I should be able to monitor it. Here's the legal reality. When you rent a unit to someone, they have a right to quiet, enjoyment, and privacy. That's been the law forever. Smart technology doesn't create an exception to that rule. If you want to install smart devices, follow the law. Get proper consent. Be transparent about what data you're collecting. Give tenants control over devices that affect their daily life. It's not that complicated. And honestly, if you're using smart technology ethically, these laws shouldn't scare you. They only penalize landlords who are using technology to surveil or harass tenants. If that's not you, you're fine. Just follow the disclosure requirements and get proper consent. Simple. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 renters who get these updates first. Click subscribe because landlord-tenant law keeps changing and you need to stay informed. All right, let's talk about the most common questions I'm getting about this law. Question 1. What if my landlord refuses to give me the device inventory I requested? File a complaint with your state housing authority immediately. In most states, failure to provide the inventory within 15 days is itself a violation that carries a $1,000 fine. Document your request in writing, send it certified mail, and keep copies of everything. Question 2. Can my landlord raise my rent if I refuse to consent to smart devices? No. That's considered retaliation, and it's explicitly prohibited under the law. If your landlord raises your rent within 6 months of you refusing consent or demanding device removal, there's a legal presumption of retaliation. They have to prove the increase was for legitimate reasons unrelated to your exercise of rights under this law. Question 3. What about common areas? Do these rules apply to hallways and building entrances? This is nuanced. Landlords can install security cameras and smart access systems in common areas without individual tenant consent. However, they still have to disclose what devices are present and what data they collect. And cameras cannot be positioned in a way that captures the inside of your unit or areas where you have a reasonable expectation of privacy. So a camera in the hallway is usually fine. A camera pointed at your door that can see inside when you open it, not fine. All right, here's your key takeaway. You have the right to privacy in your rental unit. Smart technology doesn't change that. If your landlord has installed devices without proper consent, you can demand their removal. If they refuse, file a complaint and consider legal action. Don't let anyone tell you that you have to accept surveillance as a condition of having a place to live. That's not how the law works anymore. So do me a favor. Share this video with every renter you know. Post it in your building's group chat. Send it to that friend who just signed a new lease. Let's get everyone educated on these new protections. And drop a comment below telling me, did you know your landlord had smart devices in your unit? Have you checked? I want to hear your stories because this is affecting millions of renters right now. Remember, your landlord might be counting on you not knowing your rights. Prove them wrong, stay informed, assert your rights, and I'll see you in the next video.